Hi, everybody, and welcome again to our annual offering of cutting-edge issues in commercial arbitration, which is offered by New York Law School in coordination with the American Arbitration Association, an affiliation with which the school is tremendously proud and from which it continues to receive all kinds of benefits. Our host today is Jeff Zaino. And rather than introduce him, I'd like not to take anybody's time. Jeff, just
Sure.
Go ahead and do it.
Well, thank you. First, I want to thank Peter, Rose, Jorge of New York Law School, and of course, New York Law School for this program today. It's been a pleasure working with you, Peter. I think this is our 6th program, I think, or somewhere around there.
Quite a few.
How many? 6 or 7?
Quite a few.
Yeah. And we used to do it in person. The last 2 years have been virtual, but we're getting much bigger audiences. We had over 260 people registered for today's program. 2 years ago, we renamed the program the Stephen C. Bennett Annual Program. I want to recognize a friend and former speaker of this program, Stephen C. Bennett. Stephen passed away 3 years ago and was a friend, an arbitrator, father, husband, and just a great person with a wonderful sense of humor, and he added so much to this program. We miss him a lot in our community, and I would like to do a moment of silence in honor of Steve. Okay, we have 3 cutting-edge topics tonight, like we always do each year, and we have an amazing panelists, all good friends and AAA arbitrators. Our topics are award writing, number 1. Number 2, selecting the arbitration chair. And number 3, we put a new one in here that was not on the flyer, imposing sanctions in arbitration when necessary to assert arbitrator control over the proceedings. Those are our 3 topics. Please ask questions throughout because we have different topics throughout the night. There's 3 different topics that you just heard. So ask questions throughout each segment and put it in the chat box, and Rekha and I will be monitoring that. There are 4 CLE codes, and I will interrupt the speakers, unfortunately, 4 times throughout this program. And there are 4 words, so please make sure you mark them down. You got to stay through the end to get your CLE credit, so please make sure you mark them down. Okay, and also, everyone please, it looks like everyone has muted themselves, but please make sure you can keep your camera on, but mute yourself. Okay, now it's my honor and pleasure to introduce my friend and colleague and co-moderator, Rekha Rangachari, Executive Director of the New York International Arbitration Center and founding member of the REAL, Racial Equality for Arbitration Lawyers. So I'll turn it over to you, Rekha, to introduce our wonderful panelists, and welcome, Rekha.
Thanks so much, Jeff. So my co-host, we are excited to do this session. Of course, it goes without saying, and I want to echo one more time, we cannot do programs like this without the support of New York Law School and of course the AAA ICDR, and specifically at New York Law School to Peter, to Jorge, and to Rose. With that, it is my great pleasure to give you in brief overviews of our speakers today, and then to give you sort of a lay of the land on how things will work. So we'll go in terms of their pairs. I'll introduce them and then we'll cede the floor ultimately to them. Topic 1, award writing. We have Dana MacGrath, an independent arbitrator of MacGrath Arbitration, an adjunct professor at Brooklyn Law School. You may also know her from her diversity work, including as president of Arbitral Women. She is joined by Stephen Skulnik, independent arbitrator and mediator. He is also the senior legal editor of arbitration for practical law at Thomson Reuters. Topic number 2, selecting the arbitration chair. And we have 2 firm leaders that will be co-chairing this segment. Leslie Berkoff, partner at Moritt, Hock, and Hamroff, and she is chair of the firm's dispute resolution practice group. She is joined by Rich Silberberg, partner at Dorsey and Whitney, and co-chair of the firm's international arbitration and litigation practice and class action groups. Topic number 3, imposing sanctions in arbitration when necessary to assert arbitrator control over the proceedings. The 2 co-leads on this, Richard Mattiaccio, independent arbitrator and mediator, and adjunct professor at Fordham Law School. You may also know him as chair of the Chartered Institute of Arbitrators New York branch. He is joined by David Singer, independent arbitrator and mediator. 3 segments in cutting edge time. We will keep them each to their time limits. But with that, I think we're ready to kick off the first segment. A quick preview one more time. We go from award writing, topic 1, to topic 2, selecting the arbitration chair, to topic 3, imposing sanctions when necessary. In the midst of all of that, 4 CLE codes coming at you, and we will repeat them. The CLE form and the evaluation are both in the chat, so do check there if you need CLEs. With that, Jeff, it's back to you.
Thank you, Rekha. Okay, Dana and Steve, we're going to go to our first survey question. Jorge, if you can put up our survey question on this topic. Select, okay, here we go. Rekha, do you want me to read it? I'll take the first one. What should arbitrators do in writing the award when over the course of arbitration, the parties address disputed issues that fall outside what the parties identified as the issues to be decided? And you have 2 areas. The award should address and decide only the disputed issues. The award should address all disputed issues raised over the course of the arbitration. So we'll give it about another couple of seconds. I think we're almost there. Couple more seconds. Okay, the first one looks like it's taking it. The award should address and decide only the disputed issues specifically identified by the parties for the tribunal to resolve. So I'm going to turn to, I think, Dana, you're going first on this. Your opinion on this, these survey results.
Good evening. Hello, everybody. Thank you for including me in this program. I'm really excited about this topic and the topics that we will be discussing today. The first one we started with because it's an issue that comes up a lot in almost every arbitration, and that is because as the case evolves, the issues that are presented to the tribunal evolve, and you know, the parties learn more about the evidence from the other side and present the case differently. So just to recap, I think we've got 63% have selected the award should address and decide only the disputed issues identified by the parties, and 37% have said that the award should address all disputed issues. And I think that is makes a lot of sense because it really can depend on the nature of the dispute and the underlying sort of sub-disputes that creep up over the course of the arbitration. And so when it comes to writing the award, I think from an arbitrator's perspective, you want to try to get as much certainty as possible from the parties as to what are the issues that they are expecting and want to be resolved in the award that is ultimately issued. And the arbitrator should be proactive about raising questions as to whether an issue that was simmering has now become a more central issue to the case. And likewise, if an issue that was sort of framed from the beginning as a central issue has sort of fallen away or been abandoned. And I think that the dialogue and interaction between the tribunal and the parties over the course of an arbitration really can inform what ultimately should be and will be included in the arbitration award. Some cases this doesn't come up, but when it does come up, I think it's really helpful for there to be an open dialogue. And I think that it makes sense that the audience has got sort of split views on this because you go into an arbitration with different expectations. And I think it is important that the arbitrator try to get everyone on the same page and have a common understanding of what is really to be decided and memorialized in the award. With that, Steve. want to chime in?
Of course, I agree with everything that Dana said. I think the theme, and you'll get it through our presentation, is really don't surprise anybody. So, if it appears that an issue has been abandoned, but there's no stipulation signed by the parties or on the record that the issue or claim has been abandoned, make sure that everything's buttoned up before you issue the final award, because you probably can't go back. You might be able to go back, but it's not good practice to go back and decide something after you've issued your award. So, I mean, one scenario would be if it's unclear even after the post-hearing briefing, issue a post-hearing procedural order asking the parties, are these still live issues? And then you can record their answer in the award and nobody will be surprised.
Yeah, there's a question out there already for you guys from Judge Wilson. What if the parties themselves agree on the additional issues and ask the panel to decide?
Well, if there's an issue brought up that's not part of the pleadings that the parties want to add, then it's up to the arbitrators whether to allow that or not. That really going to depend on the facts and circumstances.
Okay, another question. Why do you refer to issues rather than claims?
It could be issues or claims.
Okay.
All right, so we have for you in this topic 5 subtopics. So I think we're going to move to the next one and have the poll come up.
Yep, let's pull up the next poll, please, Jorge. We're looking here to ancillary issues, just to preempt, here we go. And so the question is, what should arbitrators do when the evidence raises issues that may be relevant and material to the outcome of the case, but the parties have not asked the tribunal to address? Option A, an award should address and decide in the award additional issues raised by the evidence. Option B, an award should not address additional issues raised by the evidence. We have 12% participating, so we'll give it a bit more time, please.
And while we're doing that, Rekha, I'm going to do the first CLE code. Okay. The first CLE, take out your pen and paper. New, N-E-W, new is the first CLE code word. Back to you, Rekha.
Okay, let's see here. We're at about 67%. I'll give it one more second. Oh, a bunch more is coming in. Okay, thank you all for logging. Here we go. We're almost at 80%. Okay, Jorge, let's flip these results. So there you have it. 41% with the award should address and decide additional issues. 59% should not address additional issues. Steve, you're kicking it off for us on this one, please.
Okay, great. Well, I'm not surprised by the answer, because if you ask that in the abstract, I think the answer should be, well, why are you doing something that the parties haven't asked you to do? And that's the nature of arbitration. I'm going to talk about 2 examples I had, and one of them, and you'll see why it made us uncomfortable to go with the answer that most of you agreed with, which is to butt out of something that the parties haven't presented. The first case was I was sitting on a panel of 3 arbitrators. One of them is on our panel tonight, but will remain nameless, and who will recognize the story right away, though. We had 2 general partners fighting with each other. One was claiming the other was stealing, and we pretty easily came to the conclusion that A was stealing from B. But when they put the evidence before us, both of them were stealing from the limited partners. And of course, they didn't want us to address that. And why would they? But we didn't feel comfortable being party to this fraud and theft. And so what we did, on a suggestion of somebody who's not on the panel, the 3rd arbitrator, was to give A his recovery, but make it conditional on him sending a notice to the limited partners that certain transactions had happened, and given them a chance to make claims against the partnership for the money that was taken. And the second example was very recent. It was a valuation that was put in based on a transaction that had happened about the time that we were supposed to be considering the valuation. And the share price was very high. And the claimant, who was seeking to be bought out, wanted us to use that transaction to value their shares. And what the problem was, that was on its face clearly an insider phony transaction. And it was done to transfer money up to the holding company and to put a much larger valuation than the shares were really worth in order to, again, cheat the limited investors. And so we looked at that, and but of course the respondent wasn't going to fess up that that first transaction that benefited them at a high share price was phony. And I didn't feel comfortable writing an award giving credence to this transaction that was phony on its face. So we reopened the award and asked the parties, we're writing the award, we are concerned about the bona fides of this transaction. It has these badges of fraud, A, B, and C. We invite you to comment. Then we got their comments, and there was no surprise when we issued the award, giving some credit to that transaction, but not as much as if it didn't have the badges of fraud. So those were examples. I know this comes up in the corruption area. There are a lot of things where there are things behind the scenes that the parties don't want you to address. But as arbitrators and members of the bar especially, you have to be concerned, I think, about being a party to dishonesty. Dana, what do you think?
Well, I think those are really interesting hypotheticals or examples of where this issue really, calls into question, like, what is the role of the arbitrator and what is, party autonomy and the role of the arbitrators. And I see it a little bit connected to the first question, what is the scope of the award? And it seems, I would say that, sometimes the tribunal, and I've been in this position, will, identify issues like Steve has described that we see as arbitrators to inform, to some extent, our understanding of an issue or claim that has been presented to be decided, but has not actually been explained in the way that we would be able to necessarily do it justice without going back to the parties and asking them to help frame the issue. So I think that the polling, again, we have polling results that are, not, overwhelmingly, on one side or the other. And I think that that is reflective of the fact that each arbitration is different, the factual situation is different, the issues evolve. But when it comes to, making, a decision and writing it up in the award, I think it's important, first and foremost, to be focused on the issues that the parties have overtly asked you to decide. But if there's an ancillary issue that may inform how the tribunal will come out on it, on one of the issues or claims to be decided, I think it's really helpful, again, to have a dialogue or go back to the parties and try to get their input so that, again, to avoid, as Steve said, the issue of surprise, but also to understand where the parties are coming from. Because as arbitrators, you're looking at the evidence sort of, with fresh eyes. The parties lived the experience that led to the dispute that brought them to you. So going back to the parties on these issues, I think is helpful and can lead to a more comprehensive award.
We just got two questions. I saw those two questions, Jeff, and they're, one from Dan Wilson and one from, I missed who it was, but they came to the same place. Like, why are you butting in, basically? And so first I answered about the integrity of the process, right, which was to not be a party to the criminality. But second, in the second case that I told you about, we may have actually helped the parties resolve the case because the award was full of a lot of the dishonesty, of at least one side. And we got a letter from the case manager about 10 days after the award saying the parties had settled the dispute and asking us to keep everything confidential. So sometimes, airing the dirty laundry will have somebody to, will cause somebody to think twice of continuing to fight when you wouldn't want this in the public record. So who knows? But the fact, the short answer was not being a party to the fraud. Should we go to the next polling question?
I think we should. Jorge? you pull it up? Okay. Length of award. Are there components of awards that are unnecessary or can be presented more succinctly? On the other hand, do the reasons that arbitrators write long awards outweigh the benefits of arbitrators striving to write shorter awards? This is an interesting question. A, an award should not exceed 50 pages. B, an award should have no page limit. So let's see what we have here. We'll give it a couple seconds. Okay.
While you're voting, Richard made a comment in the chat about
Yes.
the parties argue a contract provision. The arbitrators may think, the parties do not argue a provision of the contract that the arbitrator thinks is relevant. Well, yeah, I mean, that's part of the give and take, during the oral argument and the presentation is, well, what about this? And of course, I mean, you can't decide, you have to understand the entire structure of the contract to decide a contract dispute. And to not ask that question, I think would not be doing your job thoroughly.
Okay, Jorge, can you give us the results? Okay, it looks like the majority are saying an award should have no page limit, 68%, and on the other one, not to exceed 50 pages is 32%. So I think I'm turning to Dana on this. Dana?
Okay, Dana, you're muted.
Yes, thank you. So just as an aside on these polling questions, we had a lot of fun drafting the polling questions, but I'm having even more fun hearing and watching sort of the development of the votes, or sort of, as it incrementally goes in favor of one or another. But I think again here, I think that it's interesting that I would say there's more discrepancy between the choice here than that we've seen in some of the other polling questions, and people seem to be in favor of an award having no page limit. And I think the reason we ask this is because, some awards are for 200 or 300 pages these days, depending on the nature of the arbitration. And there's been sort of an undercurrent of, complaints about awards being unnecessarily long, and how could they be more succinct or to the point. What is it that parties really want? When you hear that people complain about long awards, what is it that they are finding problematic about the award? And so that was part of why we suggested to put this out there. And we've also suggested to put the polling questions to you sort of in a vacuum before we have any discussion of it, just to get your fresh views on it. I think that a lot of awards are long in part because they are addressing some of the sort of requisite elements of like the procedural history and some of the things that need to be in an award to have it contain all of the components, as thoroughly as possible, not overly, wordy, but that in order to be enforceable around the world, you need an award to evidence, the procedural history, the life of the case, the issues to be decided, the evidence submitted, the reasoning of the tribunal, the result of the tribunal, and that can take more pages than you think when you sit down to write, or if you were from the outside anticipating what the award would look like. So I think actually having no page limit is a good thing. I also think that a 300-page award is a lot, and it would probably be a very complicated case with a long history that would merit that. But I'll turn it over to Steve. What are your thoughts?
Well, we have a quick comment in question. If a complex case requires a very lengthy award, would the parties want to pay the arbitrator to figure out how to condense it down to 50 pages? The parties rely on the arbitrator's judgment in so many ways. Why not this one?
I'm not sure I understand the question.
It's kind of, I think more of a statement.
Yeah, it's really more of a statement. I mean, yes,
I'm sorry.
you should strive to be succinct, of course, but it really, like most issues involving the legal profession, it depends. And what I mean by that, it depends. Is this a case where somebody was complaining about the process all along, claiming that the arbitrator was not giving them opportunities to take discovery, was not doing the, or was, when it turns out that they had all the information they needed, but they're complaining anyway? Then I think you need to, I mean, one of the things you want to look to in writing an award, it's not the only thing. Some people say it's the only thing, but one of the your goals should be to avoid having the award set aside. And so a robust procedural history showing that the tribunal bent over backwards to accommodate even some unreasonable requests, and that people made concessions that they may now be complaining about, may be in order. If you've got that case where the parties are professional arbitration advocates and they don't really come to the tribunal with very many disputes, if they do, you do a Redfern schedule on documents, but that's pretty much it. I don't think you need a long procedural history at all. And that's what I think often takes the length of the award. And so it depends on how likely somebody is to complain about process, due process paranoia, as they say.
Yeah, one of our panelists has a question, David Singer. Why not consult with counsel in advance of writing the award regarding whether they have a length preference, which has cost implications?
If somebody told me, and I think Dana's just said that, if somebody told me you only have 50 pages, but it's one of those situations where you think to protect the award, you need to go through the entire procedural history, then that's your job. And for them to tell you not to do it, and I don't always invite the parties to tell us how to do our job. If we need to be longer in this particular case, and the case of the first example I gave of the case where one of our panelists was on, we knew that was going to be litigated at the courts afterwards, and we had to go through a lot of the procedure. So it really depends. I think you should strive to have, I mean, I've done many awards that are 50 pages or less, but a complex case with a lot of procedural orders beforehand, with a lot of issues, with maybe issues involving subpoenas of parties who didn't attend and all kinds of things where parties say they didn't have a chance to present their case. You need to document that. All right, so we have two more, so I think we should move on so we don't run out of time.
Yeah, just one last point.
Yep.
I just don't want everyone to think that every word in an award costs the same. So, by memorializing the procedural history of a case, it does make the award longer. It doesn't necessarily cost the parties all that much. It really, it's what's best for the parties to have an enforceable award. And there are portions of the award that can be drafted quickly. So length is not necessarily always commensurate with the time. So,
right. Well, there's that old saw that, I just wrote a 50-page brief. If I had more time, I could have written a 25-page brief. I mean, it's true. It doesn't necessarily, the length isn't going to make it more timely. The question is how thorough it should be.
Okay, so Jorge, if we can go to the next question, and Rekha, I'll take it if you don't mind, and you can do the last one if we get to it. We have approximately 10 minutes in this segment.
We're going to speak New York fast then.
All right. Okay. This is quantum issues in the award. How arbitrators approach quantum calculations. How should arbitrators ask the parties of quantum experts? A, the tribunal should decide the quantum issues and write the award based on the parties' submissions and not ask for additional materials from the parties or their quantum experts. B, the tribunal should ask for additional materials from parties or their experts if they deem such additional information relevant and materials to deciding the quantum outcome of the case in the award. So please enter your survey results. And while we're waiting, some people entered late because there was 2 advertisements for this program. One said 5:30 and one said 5. So I'm going to repeat the first CLE word for those people that came in late. We apologize for the different ads. It is new. The first CLE is new, NEW. Okay, we'll give it a few more, 100, we're at 69, 70%, okay. Okay, I think we're good because we want to have a lot of time. We'll stop it at that, Jorge. Okay, so 10% said the tribunal should decide the quantum issues and write the award based on the parties' submissions and not ask for additional materials from the parties or their quantum experts. And then the majority, 90%, the tribunal should ask for additional materials from parties or their experts if they deem such additional information relevant materials to deciding the quantum outcome of the case and the award. Was that fast enough, Steve?
That's great. So I'll go first and point out that, well, if 90% of you agree, there's not going to, I don't need to do much convincing. I mean, my whole point was that very often as arbitrators, you get two different expert reports and then two different testimonies of the experts where they're on different planets. And you can't accept one or the other because one is pie in the sky and the other one is ignoring that there's a real claim and there was real damage here. So the kinds of things that we do is we say, well, what if you were to vary the assumption? Could you run the model that way? Those are the kinds of questions that a panel will do. You can do it during the hearing. You can do it post-hearing. But if you probably want to avoid doing the arithmetic yourself. So you do want to solicit from the expert. Look, you just did a 3-year look back on a business that was already failing, but you want to try to pull in the good years when it's clear that in the year in question they really were in trouble. Can you rerun those numbers on just the last year? And take them 10 minutes to do that for you. But that could be helpful. Now you may be tipping your hand as to where you're going, but it's better that you give the parties a chance to comment, and then the parties will have a chance to say, well, look, tribunal, you asked for only 1 year, 3 years really is appropriate, and here's why. And we consider that. But you want to have the alternative calculations if you can. Dana?
I mean, I agree with Steve, and I agree with the majority of the polling responders. It is really important that the tribunal hear from the parties on what quantum aspects they should consider when they are assessing the quantum in the case. And so where different experts are either, using different analytical approaches or, any number of reasons why it would be necessary for the tribunal in order to issue an award that really reflects the parties' submissions and what the parties are seeking to have resolved in the case, to go back to them and ask for the additional information or ask them to ask their experts to put in what's necessary. I think that's, unfortunately, that can slightly elongate a case, but I think it is in the best interest of the parties if that's the way to best handle the quantum issues and get the full information. It's I think that any risk of elongating the arbitration is outweighed by being able to make an accurate quantum decision in the award. So I agree with all of you.
Well, we're on time. We have one more question, and I'll turn to Rekha for it. But I just want to make one quick comment. We're getting a lot of great feedback in the chat room. Take a look at that. Thank you for all the comments that people are making and the questions. Keep them coming. Okay, Rekha, you got the last question with Jorge. Can you pull that up?
We're going now, finally, to lack of unanimity. So when a 3-member tribunal is in agreement on some but not all issues, what are the possible approaches of the arbitrators writing the award? What is preferable? One choice. The award identifies as unanimous or majority. Dissenting arbitrator signs the award but issues a short statement of what is not agreed to. Or third, dissenting arbitrator does not sign the award and writes a dissenting opinion. Controversial. Let's see what we got here. Lots of votes coming in. We'll give it a minute. We are at 5 minutes until we switch topics. So just a time warning.
And I got to do the next code after this segment.
Okay, we're at 74%. Let's flip it. Jorge, if you could share the results. Overwhelmingly, option 2, dissenting arbitrator signs the award but issues a short statement of what is not agreed to. Okay, so I believe Steve is taking this first and then to Dana.
Right. I'm going to kick this off. It's very interesting that people took that. That's probably where I come out to and have come out. We didn't include one option, which I think is, if you take it in a progression, the first option is get back in the room and try to come up with try to get an award that you all can agree to, because that's usually the best. You shouldn't compromise your principles, but if there's a way that you could have some compromise on language that will make it happy for everybody to sign, that's best, I think. The next one was an option that I wasn't necessarily aware of until recently. I read an award in which it said, as to claim A, the tribunal holds as follows. As to claim B, a majority holds as follow, without ever telling you which arbitrator was in the dissent or couldn't support the opinion. I mean, the parties probably have a good guess because they were party appointed arbitrators. So you're probably going to guess that it was the arbitrator that was appointed by the side that lost that claim, but you don't know. So I'm wrestling with that now because I had not realized that was an option. The one that everybody seems to like is, your 2 or 3 sentences saying, I signed the award, but I would have awarded X amount damages instead of Y, or I would have not, or I would have dismissed the fraud claim, or whatever it is. Just, you don't need to go into it, but just to give the parties notice of what the source of the disagreement was. And then the third one, I think in most cases, unless you think that the tribunal really went off the rails and has done terrible misjustice, and as arbitrator, you want to help the party who lost get the award set aside, then you would write the long opinion. And luckily, I've never been that arbitrator, or only once on a tribunal where the dissenting arbitrator did that. It wasn't successful. It was not a miscarriage of justice. I was the chair and the award was confirmed. But I can see that as a possibility. Dana, what are your thoughts?
And Dana, can you actually also respond to Rich, one of our panelists, poses in the chat, what should the majority do, if anything, if a dissenter insists upon writing a long dissent? Any comments sort of there? We are 2 minutes till.
All right, Dana, you start now, and I'll try to answer that next. Go ahead.
Okay. I agree with what Steve was saying, and I think that it's interesting that the majority went with the dissenting arbitrator signs the award, but issues a short statement or issues something to the effect of where they would have come out on one of the issues or claims to issues to be decided differently. And I think that this is much more reflective of commercial arbitration than what we see in treaty arbitration. And I think that's an important distinction. And I think that dissents it's been my sense that dissents are somewhat disfavored in commercial arbitration. And we all try as arbitrators to reach, unanimity where we can, and where we can't, we thoroughly discuss the issues as to why we differ. And I think that the audience here today appreciates understanding why the arbitrators may differ on certain issues and getting some, written statement to that effect. So I think that makes sense. I'll turn it back over to Steve.
Some closing thoughts on that, Rich. In the case I mentioned where I did have the long dissent, it was a person who a party appointed arbitrator who had never been appointed before or since, and was essentially had been local counsel to one of the parties, and was not neutral, although he signed an oath agreeing to be. So I really was not much I could do with him. I tried to educate him. If the 3 arbitrators are people who are experienced arbitrators, I think you can sit down, maybe all have lunch and see if you can get cooler heads to prevail. And I don't think that that's much of a risk. There is one that came out a couple of years ago where Gary Bourne wrote a long blistering dissent. He really thought there was a misjustice. And so experienced people that can happen. But you would really try to use your skills as your people skills to see how you can avoid that.
Great. Hey, you guys were terrific. We have to move on to our next topic, but Steve, Dana, brava. You guys were great. Thank you. Really great job. Okay, so we're going to turn to our next topic. Before we go to that, though, I'm going to give you the next code, the next CLE code, and it is York, Y-O-R-K, York. Okay. All right, the next topic is with Rich and Leslie. selecting, an interesting topic, selecting the arbitration chair. Take it away, guys. Oh, Rich, you're on mute. You're on mute. There you go.
You might prefer that I stay on mute, but we'll begin anyway. All right. So good evening, everyone. As I look around the screen, I see a lot of friends and colleagues, and I'm delighted to see you. Thanks to Peter and Jeff for including all of us on this panel, which we enjoy doing every year. The topic that Leslie and I are going to cover is one that is rarely discussed in webinar type settings, and that's why we are anxious to do it. I will start with a couple of thoughts, and then I will turn it over to Leslie to start with some specifics. We look forward to your questions in the chat. So, like almost everything else in arbitration, the manner in which the chair is selected is often dependent upon the language of the clause. So in many instances, all three arbitrators are selected through the strike at rank protocol. And in that instance, the AAA will generally select the chair from among the three arbitrators who have been selected by the parties. Or else, on occasion, the AAA will turn to the three arbitrators, particularly if they're experienced, and urge them to get together and select a panel chair from among them. We are not going to talk about that. We are going to talk about a common situation that exists when each party appoints an arbitrator, and the two party appointed arbitrators then get together and select a third. And that is a protocol which is not really discussed very often. So we're going to try to provide some guidance with regard to how the two party appointed arbitrators should go about selecting the chair. A couple of thoughts. Number one, the principal reason that parties choose arbitration as a dispute resolution mechanism is self-determination. And a great deal of self-determination is dependent upon the party's ability to pick their decision maker. So in circumstances where the two party appointed arbitrators are selecting the chair, they really should view themselves as extensions of the parties, because the parties are depending upon them to select a suitable chair. And when you talk about a chair, as Leslie is going to get into in more detail, it's not just a good arbitrator. There are lots of other attributes which are equally important and could be, in a particular case, of vital importance. So I think it's very important that we all who have this very trusting role to select a chair take it very seriously and recognize that in terms of being a wing arbitrator, it may be the most important thing that you do in the case. Leslie?
Right. And I think that is really something that is sometimes really overlooked. So let's talk about this. I mean, I think the easy point that we could all agree is that the first thing that comes to mind is, well, when we're picking a chair, just as when we're picking the wings, you want someone who's a good arbitrator. You want someone who's smart, who's going to be diligent in addressing the matter that's before them, that's hardworking, that's fair, that's impartial. And those are easy, and easy in that those come to mind. But there's a lot of other things I think we want to talk about or recognize that maybe aren't as easily identifiable or aren't as recognized, and maybe we could call them soft skills, or maybe we could call them a host of other intangibles, but I think they are equally important because, as Rich underscored, the wings, their first job here is to pick the person that is going to chair this arbitration process. And if you are indeed the extension of the client that has selected you, the party that selected you, your job is to help guide and pick the person that's going to steer this entire process. So I think one of the top list items is case management. You want somebody who, in addition to being a good arbitrator, is going to have the skill set to be detail-oriented, organized, proactive, to sort of herd the ship, the wings, the process, and move things along. And yes, we recognize that we are going to have wonderful case managers that are going to be ascribed to the process by the AAA, but let's be clear, there is a lot of things that happen behind the scenes or during the course of the various proceedings that require the chair to be on top of the process, the procedure, and the wings to move things along. And I think that is very, very important. Rich, pick something else that you think is equally important.
So following up on Leslie's comment, I just want to add that I think, given there are so many arbitrators on this call, we all have to recognize that we're good at some things and we're not as good at others. Some of us are very deep thinkers, great analysts of issues, but not necessarily terrifically organized. So what I think we're looking for in a chair, as Leslie said, somebody who's got A+ skills in terms of running a case. Leslie, in response to your invitation to go to another topic, I think it's very important that the chair have great command of the institutional provider rules, assuming that it is an institution administered case. So that raises the question, for example, should a JAMS panelist chair an AAA administered case or vice versa? And I would say no. I would say that it's very important for the chair arbitrator to know the rules like the back of his or her hand. And someone who is not even on the panel is not likely to have that command. Leslie?
I would agree. And, you know, one of the, you could be the victim of your own success would take me to the next point. So someone who's very good, very organized, very well thought of, may also be really busy. And so remember, part of the reason that people are sometimes choosing to opt into the arbitration, other than the fact that the agreement prescribes for it, is that you want things heard in a fairly expeditious fashion. And you have to consider the fact that the chair may otherwise be an excellent fit, but he or she may have a calendar that means they're looking at next year before they can even lay hands on this. So you have to consider whether or not, in selecting your chair, he or she has both the time and the bandwidth to take on the matter. And that should be something that's really very well thought out and discussed, which is, do you have time? Are you available? What will be involved? You know, it's one thing to say you're interested in a matter, but if it's a 3-week matter or a 1-month matter, you know, do you really have time, or does everybody want to get dragged out for 2 years waiting for this arbitrator to have time in their schedule? So I think that's something very important that people don't think about as much sometimes as they should. Rich, we definitely have other ones.
And Leslie, I completely agree with what you've said. And to put an even finer point on it, I think you have to recognize that the chair is the person who's going to be responsible for preparing procedural orders and handling the case on a day-to-day basis. There are lots of cases where the chair, as everyone knows, is delegated the responsibility of handling discovery, so as not to increase the cost of the arbitration by having all 3 arbitrators deal with discovery matters or scheduling matters. And I think Leslie's point is well taken. When you're considering accepting an appointment as chair, you should consider whether or not you've got the bandwidth to do all of those things, because it can be a burden and it can add a substantial amount of work to what you've already staked out in terms of your role as arbitrator. Another issue that I think is critically important, and I might even put this one at the top of the list, is interpersonal skills for managing intra-panel dynamics. So in this day and age, we have lots of cases where the parties are appointing their respective arbitrators and they're all neutral. But let's face it, they're neutral, but they were selected by the party for a reason. And one of those reasons is that the party appointed arbitrators are going to ensure, if they're doing their job properly, that the party that appointed them has a fair opportunity to present its case, and to make sure that that case is considered when all of the arbitrators deliberate. So in those circumstances, the chair needs to recognize that there could be some competing interests, and the chair has to have the maturity and the ability to build consensus within the panel and to step over the minefields that are created by some of these competing interests. We just talked a few minutes ago in the prior panel with regard to what happens during the award writing phase and what happens when one of the arbitrators decides that he or she cannot join the majority. That's where the interpersonal skills of the chair come in. The chair needs to build some kind of consensus within the 3 arbitrator panel and find a way to get everybody on the same page, literally, to get all 3 signatures in line and aligned in such a way that it could be a unanimous award. So when the 2 wings are thinking about who to select, that I think is among the principal factors that should be considered.
Rich, I think you're right. It probably is towards the top. And that goes part to, case management skills. Managing the panel is equally as important as managing the process and bringing everybody together. Something else that I think is a very important construct, which is diversity. We all talk, and we all is just not us as the panel, but as the organizations, as bar associations, the industry in general. We talk about diversity in the industry, and one of the questions is, we talk about diversity in our panel, but if we have 2 parties that have selected the wings, and let's just say that we don't have a diverse panel at the moment, is the diverse question something that the wings should be considering? Now, we all know, and we've heard, and I won't make this a lecture of the business case for diversity, that it brings a different perspective, but it's an interesting question. I don't have the answer to it, although I have my thoughts on it. But if you have 2 party appointed wings and neither of which is a diverse party, should the wings be considering, if we're going to walk the walk and talk the talk that we're all talking in the industry, of suggesting that the chair should be a diverse, a person of diversity, whether it's of color, whether it's of gender orientation or the like. If people want to pop in on the chat on that one, I'd be curious about people's thoughts.
Leslie, I did put in, Leslie, if I can interrupt you for a second. I did put in there a question I had on that very issue on the New York State Bar Association blog, selecting the 3rd arbitrator in diversity. So a lot of people commented on that. So if you want to take a look at that, I don't want to cut into your time, but.
No, and I don't want to derail it, but thanks for highlighting that, Jeff. So it was something that Rich and I had a nice long discussion on, but I'm just putting it out there as a thought bubble. But I do think it's something that should be considered when you're thinking of the chair. So Rich, any other thoughts on that before we probably have 1 or 2 other points on this and we should move on to other topics?
Yes, let me add my support for the notion that not only should diversity be considered when the 2 party appointed arbitrators are deciding upon the selection of the chair, but in my view, we should demonstrate that we are committed. There have been countless webinars of this kind where we talk about diversity. Well, this is the time to exercise that prerogative, which is to urge the appointment of a diverse chair in the event that the 2 party appointed arbitrators are not diverse. In your discussions with the parties that appoint you, I think diversity ought to be raised as a factor in the selection of the chair. Some of you may be surprised to hear me say or refer to the discussions that you have with the parties that appoint you. Well, we're going to be talking about that momentarily because those discussions can and should take place. One last factor in terms of the criteria that should not be left unsaid is that the chair has to be the chief banker for the case. It's the chair's responsibility to make sure that the deposits that have been collected are sufficient to cover the services that the arbitrators are going to expend on the case. It's the chair's responsibility to avoid a situation in which the hearing is ending and the 30 days to write the award is beginning to tick, and suddenly someone discovers that there's no money to cover the writing of the award. That's the responsibility of the chair. So that also ought to be kept in mind. Leslie, are there any others that we think are less important?
Yeah, let me add just one quick. I think subject matter expertise is something that is important in certain cases. And I think it sometimes can be overemphasized. And I think that we need to consider when it really matters. And so there are probably cases where it really is very, very important to have somebody who understands the intellectual property that is at dispute, or whether it is a construction area. But I think sometimes it maybe gets a little bit more play than it needs to. So I think it is something to be considered, but let's not oversell sometimes where it needs to be raised, and certainly whether or not it matters for the chair, or whether or not having somebody at the panel, and one person on the panel may be enough, again, depending on the matter in dispute and depending upon how significant that subject matter is in terms of the issues that are in dispute, because the subject matter may not be as relevant depending upon the nature of the dispute.
Leslie and Rich, a quick question from Lou Coffey. Good question. Can a chair compel wings to share their estimates?
Well, I'm not sure how else are you going to monitor the finances if you don't have an understanding of the estimates? It's hard to be the banker if that would seem to me a little counterintuitive.
Yeah,
Rich, do you have thoughts?
My response to that would be that there's a lack of uniformity in how that issue is handled by various panels. I believe that all three panels should be open about what their estimated number of hours is. Yes, people have different rates, but that's just the way it is. Because I think that the chair, in order to coordinate the deposits, should try to provide an estimate on behalf of the entire panel. Yes, there are cases in which each panelist communicates separately with the administering institution. I don't think that's as efficient. All right, Leslie, perhaps we should go on to something that I threw out a teaser on just a moment ago, which is now that we have outlined the attributes of the person that we're looking for, should we be talking with our respective parties that appointed us about what their thoughts are in terms of who would be an appropriate chair, or what characteristics the chair should have from the appointing party's perspective? And in this particular instance, the answer is clear. I think the answer is yes. And for those of you who think that that might be an ethical issue, let me refer you to Canon 3 of the AAA/ABA Canons of Ethics for Arbitrators in Commercial Disputes. And Canon 3 is entitled, as you probably know, an arbitrator should avoid impropriety or the appearance of impropriety in communicating with parties. Section B 2B. I may have not gotten that sequence right, but trust me on the language. Quote, in an arbitration in which the two party appointed arbitrators are expected to appoint the third arbitrator, each party appointed arbitrator may consult with the party who appointed the arbitrator concerning the choice of the third arbitrator, unquote. So it's very direct. It says you can do it and you should do it. And it doesn't say what should be discussed. It's fairly open-ended, but Leslie and I are going to talk about some of the things that you should talk to the party that appointed you about, and perhaps some things that you should not. Leslie?
Right. So yeah, we both agree that you absolutely should be able to have some level of discussion with your party about certain of the topics. So for example, let's take one of the ones we left off with last, which is subject matter expertise, having a conversation with the party, the wing arbitrator, discussing with their party whether they believe there is a need for the chair to have a specific subject matter expertise. That seems to us pretty simple, pretty clear and non-controversial to get your party's opinion as to whether that's necessary. Other topics, Rich?
Next one would be case management skills. You should talk with your appointing party about the types of skills that the party that's appointed you would like to see in the chair.
I think some of the other things I would pick up as well are going to be, whether or not the chair has a view on things such as discovery or depositions. Now, recognizing that your party may be more of a lay person, it's really probably the view of what the party is expecting the arbitration process to be versus a traditional litigation. And so getting a comprehension of, do they expect this to be a much more streamlined, expeditious process, or are they looking for someone that's going to allow for some level of discovery and setting a level of expectation so that when you're looking for a chair, you're aligning with those views. That kind of discussion, I think, is also something that should be covered so that there is not a surprise in the selection process if the chair has a certain view one way or the other. Rich, along those lines, there's probably other things we would pick up on, right?
Similar to the preference of the party with regard to discovery, and in particular, whether the party wants or does not want depositions in the case, would be what the chair's attitude would be in terms of the filing of dispositive motions. That is an issue which divides arbitrators. There are lots of arbitrators who will freely entertain dispositive motions. And there are some arbitrators I know who won't, just don't believe in it. Think every case should be tried. So I think it's entirely appropriate to ask the party that appointed you about whether that party is concerned about whether the arbitrator who serves as chair has a view about dispositive motions.
I think we could get into what might be a little bit more of a dicier subject. Questions on substantive views. So for example, or substantive issues. Discussing with the party whether or not conversations with a potential chair can be had about the substantive issues that are governing the underlying dispute. I think if we were to discuss whether or not there's a concern or whether or not we wanted to figure out if a potential chair had a bias. For example, if the case involves restrictive covenants and the chair maybe has either written on or opined on restrictive covenants never exist, or they're never a good thing, or we take the blue pencil out and we always go this way or that way. That might be something that you want to explore. We'll talk a little bit about how far into the merits of the weeds you want to get. But I think a bias question or something along those lines would also be something you might want to discuss with the party as a concern, as something that you might be raising in conversations with the potential chair.
And
We
as
have
Leslie
about
points out,
Rich, 1 second. We have 5 minutes in this segment. You guys are doing terrific. I just got to do the next CLE code. The next CLE code, sorry for interrupting, guys, is law. is law, L-A-W, law, L-A-W. Okay, Rich, sorry, back to you.
and as Leslie pointed out, there's a really delicate balance here between talking about whether somebody might have a bias toward a particular type of issue, and on the other hand, whether or not there's a discussion that touches upon the merits. You're never going to want to have a discussion about the merits of the claim, period, end of story. However, there is, I think, a threading of the needle that if you're careful, you can discuss with regard to whether a chair has been published about a particular type of subject matter and whether the party has a concern about that. So be really careful. And if you are not confident in your ability to thread that needle, my recommendation is stay away from it. Okay, next, should you be discussing specific panel chair candidates with the party that appointed you? Leslie?
And I think on that, the answer is yes, because, and you and I had this discussion, what if the party previously was presented with Bob or Sally, and they had launched and had real objections to that as a candidate for whatever reason? Isn't it better to know this before you propose them? You've gone down the path and we have to start all over again. I think it's better to know it ahead of time, or not even if they've had an objection, if they previously had a matter with them and they had a terrible experience and they don't want to work with that person again. I don't see anything wrong with raising it in advance, so that, you know, or you might find out that they've worked with them before and maybe there's a conflict. So better to know it before you make the ask, to avoid the various things that could preclude or have somebody stricken down the road. In my view, it saves a lot of wasted time and effort.
All right, we only have a few minutes, so we're going
Yeah.
to go through a lightning round of a couple of other issues. So Leslie, I'll
Yeah.
throw this one to you. Should a wing arbitrator inform the other wing that she intends to consult with her appointing party concerning the selection of the panel chair?
Absolutely. You don't want somebody caught by surprise if one hears that somebody's had a conversation. So I think the wing should say to the other wing, I'm going to speak to my party. You can do the same or not. And they should each be at least open with each other about what they're talking about. They don't have to necessarily report full details back, if, you know, to the extent, unless there are problems. But I think they should be open about having those conversations. It avoids,
you.
remember, the appearance of impropriety, which we're concerned about.
If we had the time, we would have done a polling question on this, but the question would have been, is it appropriate for wing arbitrators to interview panel chair candidates? And if so, what could be discussed? The answer is yes, it is appropriate to interview panel candidates, provided that you do it together. Both wings should find a time when the panel chair candidate is available, and it should feel free to ask a lot of the same questions that we just talked about, absent the discussion on the merits. So have a discussion about what the chair candidate's position is on discovery, on dispositive motions, on availability, on conflicts, things of that kind. And here again, there is a provision in the canons that discusses how an arbitrator who is being considered should respond to questions. And in Canon 3, it reads that candidate may, quote, may respond to inquiries from a party or its counsel, and I would add, or the wing arbitrators, designed to determine his or her suitability and availability for the appointment. And in such dialogue, the prospective arbitrator may receive information disclosing the general nature of the dispute, but should not permit them to discuss the merits of the case.
And then I would add, Rich, just one or two very quick more points of things we didn't get to, but I think we could highlight. Please bear in mind that you are also allowed to do research. You know, there are things available for the wings to do research on. You can look at a panel CV, you can do LinkedIn, you can see how a chair is published, you can speak to other arbitrators about their experiences with this chair. These are all available to you. One of the other points that we both had was we obviously should be disclosing as wings to the other wing arbitrator any contacts that we have with any potential chair candidates, even ones as minimal. And I had this recently, you know, and I answered the question. I have periodically served on educational panels from time to time with one of the other wing panelists. So, you know, for whatever, I always have the view of disclose it no matter what it is, however minor it is. If somebody really thinks there's a problem with me sitting on an educational panel or knowing somebody from a hallway in AAA, but, you know, disclose is always the motto. Rich, I think I got us almost through everything except that one final ridiculous question. If Jeff, you give him 60 seconds.
I'll give 60
share a
seconds,
final
but David and Richard, don't hate me. 60 seconds to Rich.
This one's worth it. Just do the last point of the ridiculous request you got and why it's a bad thing.
All right, thank you, Leslie. So I will take only 60. And this is a real case within the last 2 months. I was appointed as a wing arbitrator. My counterparty wing, if you will, was someone who was not on the AAA panel or any of the other institutional panels. Very nice fellow. He calls me up. He says, I understand that you're quite active in arbitration. I just want to make something clear right at the outset. The chair is not going to be anyone you know. And when he described what the meaning of no is, he meant anybody I was familiar with, whether or not I had served with that person. And my response to him was, I don't know how I'm supposed to discharge my responsibility to select a suitable chair if I don't know anything about the candidates. So I had to decline his invitation to limit the potential candidates to anyone that I didn't know, and we finally worked it out.
Great. Rich, that was 61 seconds, but we're okay with that. But thank you. You guys, Rich and Leslie, you guys are terrific. Thank you so much. Great, a great topic. So we got to go to our last topic now. And David and Richard, you have hard acts to follow, but you guys are closing it out for us. Rekha, do you want to introduce our last panel or topic?
So topic.
I think we need no introduction, but the topic.
You don't need no introduction, but the topic.
Just the topic to remind you, we're talking now about imposing sanctions and control over process. So to Richard, to David, please.
Thank you very much, both Jeff and Rekha. Now you have us very, very concerned, but we'll hope to rise up. So our topic is sanctions in arbitration. And in picking this topic, we don't want to give the impression that that sanctions are the norm or even common in arbitrations, but rather I would say that sanctions are more the exception, not the rule. Most arbitrators, I think, rarely, if ever, impose sanctions. And hopefully that's because good management skills are usually enough to prevent a situation from getting so out of hand that sanctions need to be imposed. However, sometimes the usual persuasive powers of arbitrators are not enough to get the job done. A party or counsel may be really obstinate or obstructive, perhaps because they've been poorly advised or poorly prepared or just don't accept the authority of the arbitrators. But the arbitrator's responsibility to actively manage and shape the arbitration process is clear. Institutional providers expect arbitrators to control the proceedings in order to deliver an arbitration's promise of fairness and efficiency. So, for example, AAA Commercial Arbitration Rule 23 deals with enforcement powers of the arbitrator and states, the arbitrator shall have the authority to issue any orders necessary to enforce the provisions of Rule 21, which is the preliminary hearing, and Rule 22, which is the pre-hearing exchange and production of information, and to otherwise achieve a fair, efficient, and economical resolution of the case. So those are the expectations. A fair, efficient, and economical resolution of the case are expressed in one way or another in the arbitration rules of all arbitration providers, not just the AAA. And so in order to deliver on that promise, the arbitrator needs the power to enforce the rules that are set forth for a case. And so when problems arise, consider how the arbitration is being managed, how you as arbitrator are managing the process, and how perhaps you could be doing a more effective job. And with that, let's turn now to the rules, statutes that give support to the enforcement of sanctions. Richard?
Right, so there are really three sources of arbitrator authority to impose sanctions. The authority could be statutory. If we had in New York, which we don't, the RUAA, section 17 and 21 empower the arbitrators to grant broad relief, including an award of fees and expenses and an award imposing sanctions for failure to comply specifically with discovery orders. We don't have that. We have the CPLR Article 75, which is silent on this, as it is on just about every issue that's come up in arbitration for the first time since after the 1920s. But the authority can be in the case law. In the Second Circuit, at least, it's clear that an arbitrator has the authority to grant attorney's fees as a sanction, even in the face of a no fee shifting provision. And that's the Reliastar case. That's the citation is in the materials. And even if the arbitrator does not expressly invoke his power to sanction, and that's the Salas Capital Partners case. But there are some cases out there in which courts have vacated awards because arbitrators impose sanctions in the absence of express authority in the arbitration agreement or in the arbitration rules that are incorporated in the agreement. And we'll see that the AAA has a rule that incorporates that power. In some circumstances, there might be an argument under section 10A4 of the FAA that the arbitrators exceeded their powers and the award may be vacated when arbitrators award sanctions which without an express or authorization in the arbitration clause or in the rules. But the trend in the case law is to recognize some inherent authority of the arbitrators to enforce their orders as necessary to control the proceedings. And a lot will depend on whether the arbitrators are seen as by a reviewing court as having acted fairly with two main factors in mind. The first, of course, is process. Did the arbitrators hear both sides out before imposing sanctions? Did the arbitrators provide fair warning and an opportunity to cure the offending conduct before imposing sanctions? And the other main factor is proportionality. Is the sanction proportional to the offending conduct? And the institutional rules, like the AAA rules, do take these factors into account when they address the authority of arbitrators to impose sanctions. David.
And the Reliastar case that Richard refers to is interesting in the Second Circuit. In that case, the arbitration clause expressly said that each side would assume its own attorney's fees and costs. And in that case, the arbitrator awarded as a sanction attorney's fees and costs. And there was a dissent in that case because it said, hey, you have that provision, you're not to award attorney's fees. And but the majority said that, well, that restriction only applies when parties are acting in good faith. So here there was a bad faith exception that enabled them to award attorney's fees as a sanction. But going back to AAA Commercial Arbitration Rule 23, it lays out expressly, but without limitation, basic tools available to the arbitrator. And these include the power to issue appropriate orders, to preserve confidentiality, to impose reasonable search parameters for electronic and other documents if the parties are unable to agree, to allocate costs of producing documentation, including ESI, and in the case of willful noncompliance with any order issued by the arbitrator, to draw adverse inferences, to exclude evidence and other submissions, to make special allocations of costs or an interim award of costs arising out of such noncompliance, and to issue any other enforcement orders which the arbitrator is empowered to issue under applicable law. And we note under applicable law, Richard.
Yeah, the reference to applicable law in Rule 23 is important. When arbitrators are asked to issue sanctions, they should have the parties brief the extent of the arbitrator's authority to issue those sanctions and the nature of the sanctions they can issue under the applicable law. For example, there's a state law prohibition against arbitrators awarding punitive damages, prevent the issuance of punitive damages as a sanction for discovery abuse. Discretion being the better part of valor, as counsel, you probably wouldn't want to frame any sanctions request. And as an arbitrator, you probably wouldn't want to characterize any sanctions as punitive damages. But if you're the arbitrator and that's the request, you have to have counsel brief it. You shouldn't rule it out of hand. Or because you're upset about something, granted, certainly not that. Very often the sanction requested is an order precluding the introduction of evidence, and that's sometimes prompted by the provider rules that authorize such sanctions. For example, AAA Commercial Rule 23D does that. But there are special considerations in evaluating a request for a preclusion of evidence that is actually being offered at the hearing. And I'm specifically thinking of under the FAA section 10A3, refusing to hear evidence pertinent material to the controversy can constitute a basis to vacate an award. So drawing an adverse inference from a party's failure to produce evidence that the party had an opportunity to produce may be on much more solid ground, legal ground, than precluding a party from submitting evidence, even when the arbitration rules allow for that order of preclusion. And I think arbitrators need to be especially cautious in precluding evidence and look for alternative sanctions if they're looking to impose sanctions.
Rich and David, if I can interrupt, we have a good question here from our friend Mohammed. When you talk about sanctioning the party, does it include misconduct by the party's representative? In this case, the party is victim to her representative of misconduct. So what are your thoughts on that?
I would never say this to a judge, but I'm going to say it. I'm going to presume to say it to Mohammed. I'll get to that, Mohammed. Great question. We're getting to that.
Thank you. Thank you, Richard.
Thank you, Mohammed, for the question.
I'd never say that to a judge.
So, picking up on
David.
Richard's comments, as a practical matter, experience suggests that arbitrators rarely preclude the introduction of evidence. If a party claims that he's been unfairly surprised or sandbagged and seeks an order of preclusion based on that unfair surprise, the remedy may be an adjournment to allow the surprised party to prepare and respond. We're not dealing with a jury here. If inconvenience and expense are asserted against keeping the hearing open for another session or another time, we've all learned well how the pandemic, during the pandemic, how to conduct hearings remotely and to accommodate this type of thing in a more cost-effective manner. I think the bottom line is that the refusal to hear evidence should be avoided for the reasons that Richard referred to before. It's one, there are a limited number of bases for a vacature of an award, and the failure to consider evidence that should have been considered is one of those bases. So it should be avoided if at all possible, and there generally are ways to work around it. For arbitrators, make a record of having given the parties a full and fair opportunity to brief the issues before imposing any sanctions. And if you are going to issue sanctions, do them thoughtfully and reluctantly, not in the heat of the moment. If you're awarding sanctions for willful non-compliance, as referred to before, that subsection in Rule 23, do not forget to make a finding that the non-compliance is or was willful. And if you cannot do that on the record you need to look elsewhere in the rules for a basis to sanction for non-willful behavior. For counsel, similarly, welcome the opportunity to brief sanctions, whether you are in support of the award of sanctions or opposing sanctions. An arbitrator may not be well schooled on the topic, again, because they have little or no experience awarding sanctions. So always seize upon that opportunity, Richard. I think you agree.
Staying with the AAA commercial rules, Rule 23 is the foundation. I won't say predecessor because it's still very much in effect, but it's the foundation for a more recent rule that was introduced in the 2013 revision to reflect what had already become the practice, and that's commercial rule R58, which a AAA arbitrator colleague of ours in Chicago, Stan Sklar, likes to refer to as the hammer. I think of it more as a very sharp scalpel if it's used properly. Rule R58 is important, and maybe David will tell us a little bit about it.
Not only are we going to tell you, we're going to quote it because it is important. Whatever kind of cutting instrument you want to consider it to be, Rule 58 on sanctions states that the arbitrator may, upon a party's request, order appropriate sanctions where a party fails to comply with its obligations under these rules or with an order of the arbitrator. In the event that the arbitrator enters a sanction that limits any party's participation in the arbitration or results in an adverse determination of an issue or issues, the arbitrator shall explain that order in writing and shall require the submission of evidence and legal argument prior to making an award. The arbitrator may not enter a default award as a sanction. So that's specifically precluded in the AAA rules. The arbitrator must provide a party that is subject to a sanction request with the opportunity to respond prior to making any determination regarding the sanctions application. So again, due process and process is clearly required and key.
Right, due process is key. Another interesting feature of Rule 58 is that it does not require willful noncompliance, as Rule 23D does. It requires a finding that a party has failed to comply with its obligations, which is much broader. And if you look at the arbitration rules of the other providers, and I've included some links in the materials, they also authorize arbitrators to issue a broad range of sanctions for material violations of rules or orders. But the key is, for the practice note really for arbitrators, is you must give fair notice that you're considering sanctions and a reasonable opportunity to address potential sanctions, and if possible, correct that conduct for counsel to correct that conduct, or the party to correct the conduct. If you're counsel opposing sanctions, you want to make the arbitrators aware of their limits, especially if they're making angry noises at you or your client during the hearing. So you want an opportunity to brief. And if you're counsel seeking the sanctions, please don't complain that you have to submit a letter brief just because your client is whining about fees. What you're asking for is a big deal. If you think you have a decent shot at a favorable award, you will not want the sanctions you're asking for to jeopardize confirmation or enforcement of the award that you hope to win. For the arbitrators, I think the advice is take a deep breath, set a briefing schedule, be thoughtful and deliberate, and make a record that you're being thoughtful and deliberate. David.
That's right. So again, for all concerned, the AAA Rule 58 makes clear once again that a default award is not an available sanction. There's no such thing in AAA administered arbitration. However, other providers have different rules. Under CPR, for example, Rule 14, a default award is available as a sanction. That's Rule 14. JAMS Rule 29 authorizes arbitrators to limit a party's participation in the arbitration or make an adverse determination of an issue in extreme cases, quote unquote, extreme cases. So again, you're hearing the theme of treading lightly and to award sanctions reluctantly and only as necessary. As with the AAA rules, due process and proportionality of the sanction to the offending conduct are key considerations as well.
David, we're at the, David and Richard, we're at the 10-minute marker. I want to give the last CLE code. I have to do that. Okay.
Right.
The last CLE code is school. SCHOOL, school.
Jeff, I'm
Back to you guys.
shocked. I'm shocked.
Couldn't figure that one out, could you?
Would make a good game show. So let's talk about the just briefly about the typical circumstances for an award of sanctions. Where you tend to see it is in situations where there's been a failure to retain documents, especially if the arbitrators included an arbitration hold in their procedural order number 1, a refusal or failure to produce documents ordered to be produced by the arbitrators. Dilatory conduct, especially conduct that undermines or seriously threatens evidentiary hearing dates that have been set as firm in a scheduling order. But one of the issues that comes up is the appropriateness of sua sponte sanctions. And really, other than maybe daydreaming about it when parties are being particularly difficult, arbitrators should wait for a request or a motion before considering imposing sanctions. The one exception may be when conduct at the evidentiary hearing is so disruptive that it prevents the arbitrators from hearing the case. And even then, counsel should be warned in advance when this sort of conduct happens, that a continuation of the conduct may result in sanctions. And if it happens again, argument should be heard about it on both sides on the record before any sanctions are imposed. And now to Mohammed's question. Sanctions against whom? There are decisions going both ways, including within New York, on the question whether tribunals can impose sanctions on counsel. Some courts worry about depriving parties of representation or about arbitrators not having the expertise in matters of professional ethics and responsibility. Other courts uphold the authority of the arbitrators and see them as being in the best position to make the determination because they're handling the case. Generally, the institutional providers do not address sanctioning counsel. They focus on sanctions against the parties. So for example, all of the remedies mentioned in AAA Commercial Rule 23 and Rule 58 impact the parties' interest in the case, not directly the lawyers. Arguably, attorneys and other providers do it differently. The LCIA has a very different approach. Arguably, attorneys acknowledge the authority of the arbitrators and agree to abide by the arbitration rules when they appear as counsel in the arbitration. But personally, I think I would steer clear of sanctioning the lawyers. If appropriate, you can make a record that attorney conduct on behalf of the client has prompted the sanctions and let the chips fall where they may between the attorney and the client. But I think it's really not clear that in New York, at least, arbitrators have the authority to sanction counsel. Courts can be fairly jealous of their jurisdiction to discipline attorneys. David?
Okay, so thanks, Richard. So I think we're going to just recap a bit and then take any additional questions. If you're going to consider sanctions, consider your own, as an arbitrator, consider your own behavior and how well you're managing the case, and can avoid the need for sanctions by proper management. Give the parties advance notice or warning that behavior is problematic, so they're not suddenly surprised by a sanction. You can indicate your displeasure with certain behavior in advance and maybe make reference to potential sanctions before actually doing that. So have some lead up to that, so there's no surprise. Make sure that the parties brief the applicable law before going down this road. Make sure that you carefully consider whether sanctions are truly warranted. And even if they are, don't overreach. As an example, we've made references to the option of drawing a formal adverse inference in circumstances where certain evidence hasn't been produced or a witness hasn't been produced, and under circumstances that may be concerning, as an alternative to drawing a formal negative inference or adverse inference, you can simply note in your award, for example, the absence of, for example, a witness who you know to have been otherwise available, a relevant witness who was not produced, and note that in your award without formally drawing an adverse inference. So that's just another example of how one might take the less formal or extreme sanction approach. So those are some bits of advice for the arbitrator, and then for counsel.
Yeah, so I would say for counsel, don't assume that the arbitrators are powerless because they don't have the power of contempt that a judge has in the face of aggressive tactics. But I think, further advice to counsel, maybe it's obvious, but it's in my experience in dealing with counsel in cases, it's not obvious to everyone. That if you're engaging in guerrilla tactics in arbitration, you obviously don't get it. It being the fact that you're antagonizing the very people who will be deciding the merits of your client's case, and that your client really has little or no effective right of appeal, and that's self-defeating behavior. So if arbitrators are at the point where they're even considering sanctions, someone is really failing at his or her job as advocate, and maybe both sides are driven by their clients, who often can be, white hot even by the time of the hearing. So I guess the takeaway is that sanctions are, in fact, in the arbitrator's toolbox, but like scalpels and other sharp tools, they need to be handled with care by the arbitrators, and they need to be avoided by counsel. And with that,
Well, we have actually, Richard,
questions.
and Dave, we have another question from Mohammed, our friend Mohammed.
Yes.
How can arbitrators determine adverse inference in a case, or what standard or test they apply? Should they apply?
So I don't know that there are. I mean, it's the David.
I mean, if there's a certain, if there is a witness who, by all appearances would have testimony that is favorable to the other side and is under the control of the party that refuses to produce him or her, or if there turns out to have been a spoliation of a document that appears that would have been helpful to the side that that was engaged in that activity, then in those types of circumstances, it's not unreasonable to draw inferences that if the document had not been destroyed, or if the witness had been called even under your control but was not, that it would have been unfavorable to your position. So I think that's an example. There are other examples that can come up, but
yeah, I think the counsel sometimes makes the mistake of thinking, well, okay, I can ask for an adverse inference, and it makes the adverse inference so specific that it is essentially deciding the merits of the case based on the adverse inference. And in my experience, arbitrators don't do that. They will draw an inference that the absence of a document or a witness, as David says, would tend to support the other side's position. And that if they did appear, if the document had been produced, they would tend to support the other side's position if the document and the witness was in the control of the person not producing it, and it was probably asked for. But it's a general inference. It's not usually a very specific A wins, B loses, the case is over inference. It can sometimes be very, very important in context in the arbitrator's decision making. But there are no hard and fast rules that I know of for this sort of thing.
And just from for counsel, the general idea of acting poorly, engaging in bad behavior, being obstreperous, being obstructionist, you're doing it in front of the arbitrator or arbitrators who are hearing your case and are going to decide the case. So don't create circumstances that would give rise to the prospect of sanctions in the first place. And that is really, in large part why it doesn't arise. That type of behavior typically doesn't occur, and arbitrators are typically skilled in working around the prospect of such bad behavior. So it's available, it's a tool, but hopefully you don't really need to engage with it, if at all, very often.
Well, gentlemen, thank you. We're
Bad
out of
behavior.
time. Well,
We're
Richard,
out of time.
you were out of time,
So
but you
just-
have last word.
Just last thought, in terms of bad behavior, arbitrators have to get used to very different styles of advocacy and very different styles of witnesses. Some of them are more obnoxious than others. And it's part of the arbitrator's job not to be influenced by those subjective factors, and to give everyone a fair shot, even if their style may be more suited to jury trials or whatever. So these are extreme measures when you go toward an adverse inference, except when you're talking about the empty seat. Why didn't the important witness not show up? Or why didn't the document that must have existed never be produced? So those are extreme. All of this is in extremis. It's just we've not been talking about the typical situations.
Great. Well, we're out of time, unfortunately. And Richard and David, you did live up to the expectations. Thank you. You did a wonderful job tonight. and all 6 panels. You guys are the dream team panel. We came up with 3 great topics. Thanks to you guys. We greatly appreciate it. And I'll turn to Rekha. Which panel was your favorite tonight?
Totally inappropriate to end it that way. They all were my favorite, just like children. There are no favorites. So thank you so much to our experts for tuning in. 3 panels in rapid time. Please do reach out to them. Their profiles are largely available on the web to write and ask any questions. And the CLE materials were in the chat in case you needed them, and so posted. Remember to fill out your CLE form and your evaluation, and allow us not only to thank the experts, but also to New York Law School, the AAA sponsors, and to Peter Phillips.
And the audience was great tonight. All the comments, questions, thank you so much. And obviously we'll give the last word to Peter Phillips. Thank you, Peter. He froze up.
Well, thank you, Jeff, and thank you to all the speakers. You can see that New York Law School's mission, is not simply to train future lawyers, but to contribute scholarship to this field, and very importantly, to serve the community, to try to serve the professional community as a forum for stimulating and exciting and progressive ideas and suggestions. And you can see why this aspect of it's the most fun of my job. You keep being surrounded by people who are more experienced and smarter than you know what I mean? And all you have to do is just sit here and soak it in. I really do appreciate everybody's work. And this is going to end our offerings for this year. We're going to start up again in September. Everybody will get notice of our CLE offerings in the end of the summer, so you can plan for it. May I ask you, please, if you have thoughts of really exciting people or really exciting topics. We're no longer restricted to folks in the New York area. You know what I mean? We can bring in people from Singapore if we want to. And I would very, very much benefit from any thoughts that anybody has. Just email me and let me know, because I'll be working up the program over the summer, and I would appreciate very much hearing from everybody. So with that, thank you to our speakers. Thank you very, very much for all of you who are participating, and I'll see you in a few months. Thanks a lot.
Thank you, everyone.